Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration.
I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes.
And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Hello, everybody. I am not Kevin Gregg, but this is the Immigration Review Podcast, so don't panic. I'm Liz Montano. If you're a longtime listener, you might know me as the girl who occasionally hijacks the mic when Kevin dares to go on vacation. If you're new here, hi, I am indeed that girl. Kevin will be back soon, but for now, you're stuck with me. This week, we've got 6 circuit court cases on the docket. Kevin covers the first 3, and then I take over for the last 3. But before we dive in, 2 quick but very important notes. First, on July 23, 2025, the Ninth Circuit published a major opinion in State of Washington v. Trump, holding that Executive Order number 14150, yes, the one that tried to deny birthright citizenship to children born in the U.S. to parents who were temporarily or unlawfully present, is invalid because it, quote, contradicts the plain language of the 14th Amendment's grant of citizenship to all persons born in the United States and subject to the jurisdiction thereof, end quote. I'm not doing a deep dive in this episode, but maybe Kevin will in a future one. Either way, it's definitely worth a read. Second, if you hear a cat meowing or a jingling of a collar in the background of this podcast at any time, I apologize. I tried my best to get her to stop. But, as any cat parent knows, she runs the house. And, apparently, wants to be podcast famous. So, you're welcome, I guess. And, tell your cat I said hello. All right, let's get into it.
Our first case is the Silva Borges v. Bondi, published by the First Circuit on July 18th, 2025. This case is about burdens and the like, and it was actually published Friday of last week, but well, the First Circuit can be a bit sneaky with its publications. But I caught it, everyone. I caught it. Mr. de Silva Borges and his family are allegedly from Brazil and entered the U.S. without authorization, allegedly, in 2021. DHS served them with notices to appear, charging them as inadmissible under INA Section 212A6A(I). Based on DHS's then correct interpretation of the law, the family was not subject to mandatory detention and litigated their removal proceedings in court, as is their right. At their first hearing, DHS filed a, quote, summary, end quote, for each respondent, which also included an I-213 narrative. Pretty standard filing. The Borges family denied all factual allegations and the charge of removability, as is their right under the regulations. Then the family moved to terminate based on DHS's failure to meet its burden to establish alienage. Y'all listening up, non-citizens bar? It's about to get interesting. As to those summaries, well, the family argued they were, quote, incoherent and notably failed to reference any passport or other documentation to demonstrate their alienage, end quote. So like it's just DHS's own hearsay allegations submitted to meet its burden. Quote, specifically, they claim that the summaries omitted the name of the officer who examined them, the disposition of the examination, the signatures of both the Border Patrol agent and examining officer, any mention of a foreign passport or other identity document, and any information about their last entry in the United States and their place of permanent residence, end quote. Y'all listening? Confident that that stuff didn't matter, DHS didn't file a written response, although they did respond orally at a later hearing. An immigration judge denied the motions, ordered the family removed, and the BIA eventually affirmed. By the way, there were other errors in the summaries too. Quote, for example, the family pointed out that the summary for their then 2-year-old child claimed that the child indicated that they understood their right to communicate with a consular officer, but declined to speak with anyone at this time, end quote. A somewhat split First Circuit reversed and remanded the BIA's affirmance of the IJ's denial of a motion to terminate. Because fortunately for the family, the First Circuit published Rosa v. Bondi a few months ago, episode 255, and recently slightly modified. As that decision explains, agreeing with at least the Sixth Circuit, the statute provides DHS a burden to establish alienage by, quote, clear, unequivocal, and convincing, end quote, evidence. That's different than clear and convincing evidence. So when an IJ uses that phrase, as occurred here, and the BIA affirms by saying that the standards are the same thing, well, both tribunals are wrong. Recall, too, that standard comes from the Supreme Court's Woodby v. INS decision from a long time ago, so, it should apply everywhere. And it's a really high standard, guys, that DHS must meet. We should be putting DHS to its burden if it helps your client. Quote, unequivocal, taken by itself, means proof that admits of no doubt a burden approximating, if not exceeding, that used in criminal cases, end quote. Oil was in trouble then and tried to argue that the Supreme Court has later said that the phrase actually means just clear and convincing evidence, but well, the First Circuit was very much not convinced. Unequivocally so. So given Rosa, the court has sent the matter back to the BIA and maybe the IJ to determine if those summaries, flawed as they apparently are, meet that standard. Judge Howard concurred, agreeing that Rosa controlled but not loving it. And congratulations, Annalise Mde de Rojo and Stephanie Fisher for petitioners. And that is the Silva Borges v. Bondi. Next is Perez Cruz v. Bondi, published by the Ninth Circuit on July 21st, 2025. This case is about Convention Against Torture Protection. Mr. Perez Cruz is from Mexico and, because of a money laundering conviction, is eligible only for cat protection from return to Mexico. His claim is based on his, quote, unfortunate history with the cartels, end quote. It begins because, quote, he was the frontman for Los Dos de Nuevo León, a band well known in northern Mexico after its hit single, El Corrito, end quote. Anyone know that song or that band? I must confess my ignorance. And I'm sorry, so I tried to watch the video on YouTube, but every time I tried, 3 times, I had to first watch a DHS ad featuring Kristi Noem thanking Mr. Trump for securing our borders. What a world. What an algorithm. Still watch the music video. Pretty good. The band was kidnapped by a cartel in 2004 and forced to play an event under threat of death. They did, and then they were released. Then in 2009, Mr. Perez Cruz and his brother, who was also the band manager, were surrounded by the cartel, bound and beaten for hours. The cartel said they owed them money. Mr. Perez Cruz suffered a broken nose and ribs. Pretty terrifying. None of it was reported to police, though. Still performing, though. And Mr. Perez Cruz, quote, visited Mexico without incident nearly 400 times after his second kidnapping, end quote. Then in 2018, cartel members went to his ranch and threatened to kill him, but he wasn't there. And he kept going to Mexico after that. Then there's this conviction in the United States. Then the cat claim. Surely happening from his immigration detention, the audio went out a few times during his hearing. At that merits hearing, Mr. Perez Cruz added some facts and details. Seemed like we're talking about the Gulf Cartel here. And Mr. Perez Cruz claimed that he cooperated with the U.S. government against them and that the cartel knew it. The IJ and the BIA denied, mostly on a lack of Mexican government acquiescence to the torture and as the CAD requires. The Ninth Circuit affirmed. Seems like the court can't get over those 400 returns after the second kidnapping. And that cooperation stuff with the U.S., quote, tenuous, end quote, based on a series of suppositions to the Ninth Circuit. Plus, in further support of the agency's denial, quote, in 2019, the Mexican federal police, whom Mr. Perez Cruz alleges were affiliated with cartels who persecuted him, was disbanded and its assets were transferred to the National Guard. By constitutional amendment, responsibility for combating domestic criminal groups was transferred from the federal police to the military. Although issues remain, evidence shows that the military has effectively policed its own ranks, end quote. And the last direct incident to Mr. Perez Cruz happened over 14 years ago. Mr. Perez Cruz also alleged that the agency didn't consider all evidence supporting his claim, but, quote, we have long recognized a presumption that the agency reviewed all relevant evidence submitted to it, end quote. It therefore falls to a CAT applicant, explains the Ninth Circuit, to prove otherwise, to prove a negative. Mr. Perez Cruz did not do so. Indeed, and although this is technically EOIR, quote, the presumption normally attends the Department of Homeland Security's actions, end quote. Do tell. In this context, quote, a petitioner must identify something about the record which indicates it was not fully reviewed, such as indicators that the agency misstated the record and failed to mention highly probative or potentially dispositive evidence, end quote. Again, unmet. Got to be really specific and detailed about what evidence you're talking about that the agency didn't consider, even to have a chance to rebut this amorphous presumption. Quote, if a petitioner makes an extraordinary argument that government officials are acting extra-legally, they must satisfy their heavy burden to receive extraordinary relief. Mr. Perez Cruz fails to do so, end quote. Finally, Mr. Perez Cruz argued that the audio issues prejudiced his claims, quote, including his ability to convey to the IJ that his second brother was recently kidnapped by cartels in relation to cartels' threats against him, end quote. But even if it's a due process violation, Mr. Perez Cruz still needs to show prejudice, and the Ninth Circuit didn't see it. Indeed, apparently, quote, while audio issues arose in other parts of the hearing, none were present during the discussion of his previously unmentioned brother's kidnapping, end quote. To the extent there was confusion, explains the court, it was due to Mr. Perez Cruz's disjointed testimony. And for all of those reasons, the Ninth Circuit denied the petition. And that is Perez Cruz v. Bondi. Moving on to Singh v. Bondi, published by the 10th Circuit on July 22, 2025. This case is about mental health and competency. For reasons that appear to have nothing to do with any criminal history, DHS kept Mr. Singh, the asylum seeker, detained during his entire asylum process. Quote, while awaiting his hearing before an immigration judge, Mr. Singh began a 74-day hunger strike to protest the conditions at his detention center, eventually resuming normal eating habits approximately 3 weeks before his asylum hearing. Nevertheless, Mr. Singh sought a continuance on the ground that he lacked the competency necessary to participate in the immigration proceeding as he recovered from his prolonged hunger strike, end quote. In between all of that was court-ordered force feeding, by the way. An immigration judge denied the continuance. Mr. Singh then apparently refused to sign his Form I-589 and so was ordered removed and that he had abandoned his relief. The BIA affirmed. Before the 10th Circuit, Mr. Singh, through counsel, argued that he hadn't been competent below. Stepping back, he's part of the Man Party in India and alleged that he feared the Badal and Congress parties in that country. He described beatings and death threats, as well as police who didn't believe him. He was detained again the whole time in immigration court because he had been processed for expedited removal when he arrived in the U.S., but he passed his credible fear interview, giving him these asylum proceedings. Attorney General Barr changed the rules to hold that people like this can't get bond hearings, and Attorney General Garland did not disturb that. The 10th Circuit affirmed the agency. In the 10th Circuit, at least, quote, the test for determining whether a non-citizen is competent to participate in immigration proceedings is whether he or she has a rational and factual understanding of the nature and object of the proceedings, can consult with the attorney or representative if there is one, and has a reasonable opportunity to examine and present evidence and cross-examine witnesses, end quote. Only where there are indicia of incompetence need an IJ inquire further about safeguards and the like. Nothing more was required here, explained the 10th Circuit. By the time of the final hearing, for example, Mr. Singh had been eating for 3 weeks. He appeared healthy and with good demeanor to the IJ, and he answered the court's questions. Quote, the IJ further noted that Mr. Singh's lack of understanding arose only after an extended discussion about a continuance, end quote. Emphasis by the court. The IJ also properly considered the medical evidence, explained the 10th Circuit, quote, without any concrete medical evidence that Mr. Singh was not able to understand the nature and object of the proceedings, we cannot conclude that the IJ erred by finding Mr. Singh competent to proceed. After all, the mere inability to remember certain events and give certain testimony does not amount to mental incompetency, end quote. The only contrary evidence of the court came from Mr. Singh's attorney's observations himself, which the court describes as, quote, self-serving, end quote. At the end of the day, Mr. Singh, quote, was able to submit relevant evidence, including a detailed asylum application form, was capable of responding to extensive questioning, and failed to link his medical condition to indicia of incompetence beyond conclusory predictions by his physicians and attorney, lending support to the agency's finding that Mr. Singh was competent to proceed, end quote. As to the denial of a continuance, the 10th Circuit saw no abuse of discretion. Mr. Singh had already received several, and again, he had been eating for weeks, and he had an attorney. The court just isn't very sympathetic, even assuming Mr. Singh's claims. Quote, for one thing, his inability to testify stemmed from a self-imposed hunger strike. To be sure, we do not doubt the sincerity of Mr. Singh's efforts to protest his treatment while in DHS custody. However, as a general matter, it is difficult to see how self-inflicted incapacitation qualifies as a good faith effort to be ready to proceed, end quote. Plus, Mr. Singh didn't identify what he would have got and obtained with a continuance. Particularly problematic given that his asylum finding was already, quote, a large volume, end quote. And for all of those reasons, the 10th Circuit dismissed Mr. Singh's petition for review. And that is Singh v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
All right, now I'm taking over for the last three cases. Next up, Cano-Gutierrez v. Bondi, published by the First Circuit on July 24th, 2025. This case is about the nexus requirement for asylum, claims allegedly based on generalized violence and issue exhaustion. Mr. Cano-Gutierrez is a native and citizen of Guatemala. His claims stem from a series of 5 armed robberies he experienced as a teenager on his way to school in Guatemala. He testified that he encountered assailants at gang-controlled checkpoints who pointed guns at him and threatened to assault him if he didn't hand over his belongings. However, according to the IJ, Mr. Cano-Gutierrez did not, quote, describe the severity of any harm or suffering he experienced, end quote. And he also admitted that the robbers never threatened his family and didn't actually try to recruit him. In fact, when asked to name the gang responsible for targeting him, he clarified that it wasn't actually gangs, but instead were, quote, people that went out onto the street to rob others, end quote. And when asked why he was targeted, he admitted that it wasn't personal, that, quote, many others, end quote, were robbed too. He also explained that these incidents mostly occurred in isolated areas and during school fairs, when there were more people around. He and a friend even developed a strategy to avoid being singled out by thieves. In any event, fearing that, quote, gang members would kill him, end quote, Mr. Cano-Gutierrez fled Guatemala in January 2018 and entered the United States without inspection. He was issued an NTA in April 2018, charging him as inadmissible under INA 212 A6AI. In December 2018, he applied for asylum, withholding of removal, and protection under the Convention Against Torture, claiming he feared the robbers would harm or recruit him if returned, based on his membership in 2 different particular social groups. First, quote, young men, end quote, and second, quote, school-aged children, end quote. The IJ found his testimony credible, but denied all forms of relief for multiple reasons. Starting with asylum, the IJ concluded that the robberies did not rise to the level of persecution because he, quote, had not described physical injuries requiring any medical attention or hospitalization and had never been detained or kidnapped by the persons who robbed him, end quote. The harm, in the IJ's view, did not go beyond general criminal violence. The IJ also rejected Mr. Cano-Gutierrez's proposed particular social groups, namely young men and school-aged children, finding that they were not sufficiently particular to qualify under asylum law. And even if they were legally cognizable, the IJ found no evidence that he was targeted because of his membership in either group. Instead, the IJ found that the record showed that, quote, the robberies happened so that these criminals could enrich themselves, end quote. As for future persecution, while the IJ noted that the evidence showed, quote, generally harsh conditions, end quote, in Guatemala, the IJ ultimately concluded that Mr. Cano-Gutierrez didn't, quote, distinguish why he would be more likely than not to be targeted than anyone else, end quote, in Guatemala, quote, much less on account of a protected ground, end quote. Turning to withholding of removal, the IJ explained that because Mr. Cano-Gutierrez couldn't meet the lower burden for asylum, he couldn't meet the higher burden for withholding either. Finally, The IJ denied cat protection, finding that Mr. Cano-Gutierrez had not shown that Guatemalan officials had harmed him or that the government would acquiesce in any future torture. The BIA affirmed across the board. It agreed that the robberies fell short of persecution and that there was no nexus between the harm and any protected ground. It also concluded that Mr. Cano-Gutierrez had not shown that his fear of future harm was objectively reasonable. As to withholding of removal and cat protection, the BIA deemed both issues waived because Mr. Cano-Gutierrez did not raise any argument about withholding on appeal and had not challenged the IJ's finding regarding government involvement for cat protection. Mr. Cano-Gutierrez then petitioned for review to the First Circuit. As to his asylum claim, Mr. Cano-Gutierrez challenged the agency's persecution and nexus findings, arguing that the agency failed to consider his young age and the repeated nature of the robberies. But the First Circuit wasn't persuaded. The First Circuit focused only on the key issue of nexus, whether Mr. Cano-Gutierrez had shown that his status as a young man or school-aged child was at least one central reason for the persecution, and held that because that issue was outcome determinative, it did not need to address any other issues. On this nexus issue, the First Circuit found that the record supported the agency's conclusion that the robberies were motivated by greed, not by any protected characteristic. The court quoted Mr. Cano-Gutierrez's own testimony, where he stated that, quote, "they robbed many others," end quote, and that the thieves, quote, "just wanted to take our belongings," end quote. And like the agency, the First Circuit acknowledged that the country conditions evidence did document and reference the impact crime and violence in Guatemala has on school-age children. But the court ultimately found that this evidence was only, quote, "in the context of the general impact it has on quotidian life in Guatemala," end quote, and was too general to support his individual claim. And as for the cat claim, the court didn't even reach the merits. Because Mr. Cano-Gutierrez had failed to challenge the IJ's findings on government involvement before the BIA, the First Circuit, quote, "declined to entertain Cano-Gutierrez's cat argument for lack of exhaustion," end quote. And so, the First Circuit denied the petition for review. This case, and the next case, spoiler alert, is a great reminder to preserve all claims on appeal. Once a point is waived before the BIA, it's often gone for good. And that was Cano-Gutierrez v. Bondi. Next up, Gomez-Gabriel v. U.S. Attorney General, published by the Third Circuit on July 24th, 2025. This case is about the nexus requirement for asylum claims allegedly based on generalized violence and issue exhaustion. Now, if you're asking yourself, hey, didn't she just say that for the last case? You are correct, and you get a gold listening star. The First Circuit and the Third Circuit published two cases this week that are very similar in the issues that they address. However, the Third Circuit here took the opportunity to clarify an important point about issue exhaustion in the context of a BIA summary affirmance. Spoiler alert, a summary affirmance from the BIA, at least in the Third Circuit, does not rescue unexhausted claims. Let's back up and walk through the case. Ms. Gomez-Gabriel is an indigenous Mayan woman from Guatemala. She and her son fled Guatemala after a series of encounters with gang members. According to her testimony, gang members harassed her on her way to work on about 10 occasions, and on at least one of those occasions, they threatened her with a weapon. After that threatening incident, she avoided the road where the harassment occurred and didn't have further run-ins with the gangs. She and her young son entered the U.S. without inspection in November 2015. They were detained for 12 days, and during that time, DHS informed them of the one-year filing deadline for asylum. They were released and later filed applications for asylum, withholding of removal, and cat protection in August 2017. Yes, if you're following along, that is after the one-year filing deadline. The IJ denied relief across the board. The IJ first found that the asylum application was time-barred and that the remaining claims, including withholding and cat protection, were without merit. The petitioners appealed to the BIA, which affirms without opinion under 8 C.F.R. section 1003.1(e)(4), or what we all know as a summary affirmance. Turning to the Third Circuit, the court first addressed issue exhaustion, beginning its opinion by stating that, quote, our law was not clear as to whether a BIA summary affirmance, as the agency employed here, resuscitates unexhausted claims. So we confirm today that it does not, end quote. As the court explains, although exhaustion is no longer jurisdictional under the Supreme Court's decision in Santos-Zacaria v. Garland in 2023, quote, once the government raises the issue, we still must enforce it, end quote. The Third Circuit highlighted that the standard for a petitioner to preserve an issue for appeal is not high, requiring, quote, only that the petitioner makes some effort, however insufficient, to place the board on notice of a straightforward issue being raised on appeal, end quote. But, according to the Third Circuit, the petitioners here didn't even meet that standard. They, quote, did nothing to put the agency on notice that they took issue with the IJ's conclusions regarding the asylum time bar or CAT, end quote, and instead they challenged only the substantive merits of the claims. The Third Circuit then clarified in no uncertain terms that, quote, where the BIA merely affirms without an opinion, as it did here, its decision does not displace the mandatory exhaustion requirement, end quote. This is because when faced with a summary affirmance, the reviewing court has no, quote, indication that the agency considered something other than the issues a petitioner presented. Reviving issues that the BIA presumably did not consider would put us in the position of leapfrogging over the agency's first-line review and interfering with the authority Congress delegated to the agency, end quote. Therefore, because petitioners did not raise the one-year filing deadline or CAT in their BIA appeal, those issues were waived, and the Third Circuit did not consider them at all. So that leaves only the withholding of removal claim. Ms. Gomez-Gabriel argued that she was targeted because she is my mom and because she is a woman. But, according to the Third Circuit, the record didn't back that up. The Third Circuit agreed with the IJ that the gang members were motivated by money, not by any protected characteristic. Ms. Gomez-Gabriel did testify that the assailants had mocked her for being indigenous on one occasion, but she didn't provide much context or detail. And on the occasion she was threatened with a weapon, the criminals didn't mention any of the protected characteristics. On the whole, the Third Circuit believed Ms. Gomez-Gabriel's testimony indicated that, quote, despite the attackers' alleged use of ethnic slurs on some occasions, they were motivated not by animus towards Gabriel Gomez's group membership, but by financial gain, end quote. And so, while the Third Circuit, quote, sympathizes with Gomez-Gabriel's fear of gang violence, end quote, it denied her petition because, quote, a petitioner targeted out of a simple desire for money has not experienced persecution on account of a ground protected by the INA, end quote. And so, the Third Circuit denied Ms. Gomez-Gabriel's petition for review. The Third Circuit's decision here in Gomez-Gabriel, like the First Circuit's decision in Cano-Gutierrez, is a good reminder for practitioners to raise every issue you want preserved for federal court review, and that you cannot rely on the BIA summary affirmance to act as a Band-Aid for what wasn't raised. Because, at least in the Third Circuit, the BIA summary affirmance will not save the failure to exhaust. And that was Gomez-Gabriel v. U.S. Attorney General. Next up, Cabello Garcia v. U.S.CIS, published by the Ninth Circuit on July 22nd, 2025. Now, this case is not on petition for review. It is a case about whether the district court has jurisdiction to review USCIS's denial of an adjustment of status application under INA Section 245M, or 8 U.S.C. 1255M, which is adjustment of status for U visa non-immigrants. The short answer, according to the Ninth Circuit, is no, it does not. Let's break it down. Ms. Cabello-Garcia was granted U non-immigrant status and later applied for adjustment of status under 8 U.S.C. Section 1255M. USCIS denied her application, not for any criminal issues, not for any discretionary issues, but only because she didn't submit the required I-693 medical examination form. Ms. Cabello-Garcia had submitted partial vaccination records, but she never submitted the complete I-693 form. Instead, she had requested that USCIS approve her application without the form because she had severe anxiety and panic attacks related to receiving medical services. And she also claimed that USCIS lacked the authority to request this information. But USCIS denied. Ms. Cabello-Garcia filed suit in district court under the Administrative Procedure Act, challenging USCIS's denial as arbitrary and capricious and claiming that USCIS lacked the statutory authority to require medical examinations and health-related information from Section 1255M applicants. The district court dismissed her claims for lack of jurisdiction under 8 U.S.C. Section 1252 A2BI, of course, relying on Patel v. Garland. Ms. Cabello-Garcia timely appealed to the Ninth Circuit, and the court deferred submission of the case pending the eventual decision in NACA v. USCIS, which the Ninth Circuit published on August 6, 2024. In NACA v. USCIS, the Ninth Circuit held two things that are relevant to Ms. Cabello-Garcia. 1. 8 U.S.C. Section 1252 A2BI strips district courts of jurisdiction to review the denial of relief under 8 U.S.C. Section 1255, quote, regardless of whether the judgment, decision, or action is made in removal proceedings, end quote. But 2. 8 U.S.C. Section 1252 A2BI does not strip jurisdiction to hear, quote, collateral challenges to generally applicable agency policies and procedures, end quote. Using NACA, Ms. Cabello-Garcia asserted that her claim was a, quote, collateral challenge, end quote, to a USCIS policy, namely, that applicants under 8 U.S.C. Section 1255M should not be required to submit I-693 medical exams. However, the Ninth Circuit decided that NACA's collateral challenge exception was not applicable to Ms. Cabello-Garcia's case. As the Ninth Circuit explains, a, quote, collateral claim is one that challenges generally applicable agency policies without referring to or relying on denials of individual applications for relief. But once a plaintiff has applied for adjustment of status and the agency has denied it, the plaintiff ceases to have the collateral claim that NACA envisioned, end quote. So here, because USCIS denied Ms. Cabello-Garcia's individual application for adjustment of status, the Ninth Circuit determined that she did not bring a collateral claim under NACA, despite the fact that Ms. Cabello-Garcia's adjustment application was not brought in removal proceedings or as an application for relief. Now, if you're a U visa practitioner, or you're just knowledgeable on these issues, you may be yelling at your speakers, saying, but the IJ doesn't even have jurisdiction to review an adjustment of status application under 8 U.S.C. Section 1255M because the statute gives exclusive authority to DHS. And you'd be correct. And Ms. Cabello-Garcia raised this exact issue to argue that if jurisdiction is stripped in the way the Ninth Circuit says it is, then it would be unconstitutional as applied to U visa adjustments under 8 U.S.C. Section 1255M because by statute and regulation, she cannot obtain review of USCIS's denial of her application in removal proceedings before an IJ. But according to the Ninth Circuit, this was just a slight hiccup for Ms. Cabello-Garcia, as, quote, Cabello will be able to argue in any future removal proceedings before an IJ or later petition for review in a court of appeals that some adjudicator, the IJ, BIA, the Court of Appeals, or all of them, must be able to review her denial of Section 1255M relief as a matter of due process, end quote. But she just couldn't do it in this case. And I know, now you're probably saying, well, even if that made sense, wouldn't that take an extremely long time? And again, you are correct. And the Ninth Circuit recognized this, stating that, quote, this could delay Cabello's ability to challenge USCIS's denial of adjustment of status, end quote, and, quote, might put Cabello in a difficult situation if she is under an order to leave the United States by a date certain, end quote. But this was merely a, quote, bet the farm problem, end quote, and did not warrant immediate judicial review. And so, the Ninth Circuit affirmed the district court's dismissal of the case for lack of jurisdiction under 8 U.S.C. Section 1252 A2BI and, of course, Patel v. Garland. And that was Cabello-Garcia v. USCIS.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.